the wider community and businesses in Northern Ireland.
My Lords, it's a pleasure to rise in the wake of the speech by the Noble Baroness Lady Ritchie of Downpatrick. I would like, if I may, to make a small preliminary remark, which is that although I count myself as a unionist in the general terms of supporting the United Kingdom, I'm not and never have been connected with the unionist tradition in Northern Ireland. In fact, the first time, before I entered your Lordship's house, I hadn't actually, I think, met a unionist politician from Northern Ireland, with the exception of one meeting with a former First Minister, Peter Robinson, and even then he was judiciously balanced by his deputy, Martin McGuinness. So that is the extent of my connection with the unionist tradition. I make that point because the points I want to focus on today and the time allotted, if I may, are points that I regard as having constitutional and democratic significance for every part of Northern Ireland and every person there, irrespective of which community they belong to or whether they belong to any community at all. And so, if I could, I would like to do that. In doing so, it may be thought that I am making some remarks about the report of the committee, which might be regarded as less than wholly obliging. If that is the case, then let me assure noble lords that it is not meant to detract at all from the report as a whole, which I found extremely valuable, very informative and very useful, and which, and indeed I have learnt much, even in both from the report and in sitting in this debate, and I can say that since, without hurt to anyone, since I appear to be the last backbench speaker. But let me come to my 3 points, if I may. The first is there is a tone throughout the second, or the more recent report, of a parity of treatment of the two parties to this Northern Ireland Protocol, the British government and the European Union. And that insofar as it isn't working, or the mechanisms are not working, blame can be equitably distributed in a sort of Olympian fashion between the two. And, my lords, I think this is a huge mistake. Because while it may be perfectly true that, looked at purely from the point of the Northern Ireland Protocol, the two parties have entered it as sovereign equals, the responsibilities of the British government in Northern Ireland go way beyond simply the management of trade and a trade border, in a way that is simply not true of the European Union. It is the British government working with the devolved administration when appropriate, and as under the devolution settlement, that is responsible for housing people, for their health, for their transport, for their connectivity, and crucially, of course, for their safety and their security. Those responsibilities are not shared by the European Union, and they place a different burden on the British government as it approaches and interprets the protocol. His Excellency, the EU ambassador, is quoted in the report as saying that the EU has an economic, a diplomatic, and even an emotional and financial commitment to Northern Ireland. That is all very well. That is not to share in the responsibility for the government of Northern Ireland and the accountability to the world at large and to the democratic world at large for how the country is conducted. So I do think that should be recognised, and in my own case that would lead me to cut a bit more slack to the British government in this allocation, this Olympian allocation of blame between the two parties, because the pressures and demands on them are so very much greater. The second is, this is referred to in the report, and it's been explicitly referred to by the Noble Baroness Lady Suttie, is the fact that this is a significant constitutional change in Northern Ireland that has been imposed. Now, I know the Northern Ireland Protocol on page 1, paragraph 1 or something, really early, says this represents no change in the constitutional position of Northern Ireland. But I've always thought that's a little bit like the burglar leaving a note saying he hasn't actually burgled you. It reads well, but it bears no relation to the facts. The fact is there has been a very significant constitutional change, It is one that clashes with the Good Friday Agreement. We have seen, for example, that the vote that is to take place in the Northern Ireland Assembly has actually required legislation since the protocol was put in place in order to change the Good Friday Agreement so the vote can take place on the basis which the protocol agreed. And that seems to me to leave us in no doubt that whereas the preeminent constitutional document under which Northern Ireland was governed until recently was the Good Friday Agreement, it now seems to me that without that being abrogated or abolished, nonetheless, the preeminent document which now governs it is the Northern Ireland Protocol. Now, nobody in Northern Ireland has been asked about this. The riposte that people in Northern Ireland voted by a majority of 55% to stay in the European Union just doesn't cut it. Because what people were not asked should Northern Ireland stay in the European Union. In fact, that would have been asked to ask a question which would invite a major contravention of European Union law, because the European Union doesn't admit bits of states to membership of the European Union, only whole states. The question asked was, should the United Kingdom leave or stay? And the answer to that is not necessarily what the people of Northern Ireland wanted, but it was clear by a majority vote what the outcome was. It was a vote for the status quo. I think we can all agree on that. And I think we can all agree that what they have got in return is not the status quo. So that's why I think that argument simply fails. And I do think that this deserves more prominence, because if we were talking about a change in government and a change in constitutional status for another country, there would be many people in your Lordship's House, quite understandably, who would say that such a change would require the consent of the people involved, and it has not been achieved. After all, we offer referendums for much lesser matters than this. The people of London were offered a referendum in which they voted yes in order for the introduction of the Greater London Authority. Now, that is merely, if I may say so, though I had some involvement with the Greater London Authority, that is a modest constitutional change, it seems to me, compared to what has happened in Northern Ireland, and yet the people were actually consulted and asked. This, I think, is the sort of thing that should be high on the committee's agenda, and it should be something that the government, if I may say to my noble friend the Minister, should be much more voluble about. However implicated they may be in it, it simply isn't right. The third is, and this is also mentioned in the report, and here I trespass on dangerous ground for me because I'm not a lawyer, is the reference to Article 3 of the first protocol of the European Convention on Human Rights, which of course guarantees, as a human right, without any qualification on the face of the convention that I can see, the right to a regular secret vote for a legislature, this presumably being the legislature that is making your laws, as opposed to a different legislature. That's implicit, and I think we can probably all agree on that. Now, a judge in Northern Ireland has decided that the current situation does not breach that convention right. This is subject to appeal. I'm not going to go further into the legalities of that. It is, I understand, subject to appeal. My reading of the judgment was that he didn't actually dispute the facts, but felt that there were circumstances justifying departure from the application of the right. But I'm not a lawyer and not too careful to read into that. But I'd make a slightly different point about this. Even if it did turn out that the current situation, where amendments to the existing legal framework can be made without any say by the people of Northern Ireland in laws that they're obliged to live under, even if it turned out that that was compliant with the Convention, is that what we'd want in Britain? Is that what we'd welcome in the rest of the world? My noble friend, Lord Hannon of Kingsclere, disappointed me slightly when he said these were difficult issues. They're not difficult issues. The response to a lack of democracy in a democratic state is democracy. And I think we should actually start to address that and return to the... So I'd like to see these issues, if I may say so, more to the fore in discussion. They are issues that affect the entire community, and they're issues which we would expect other countries to address and put at the forefront if we were talking about them. We owe it to the people of Northern Ireland, to ourselves, that we should do the same when we're discussing their affairs.